you're concerned that Mr. Driscoll might be asked to give his thoughts about whether a particular withdrawal, if you will, from the account, a check cut or something, was appropriately an estate expenditure or not.
Well, I'm not so much concerned about that. I don't think the state would ask that type of question because it doesn't seem like an appropriate one for this witness. I think my concern is more if that's not what this witness is testifying about.
Then what's he rebutting?
Yes.
Okay. Anything else?
No, Your Honor.
Okay.
Well,
We'll work our way down. Nothing else from Ms. Clark. Mr. Samuel, I did get your proposed amendment to the jury charge reflecting our discussion about accident, criminal negligence, and the lesser included, and it had a few other pieces as well. And I started working through that this weekend. So received, and I owe everyone a revised draft.
And we're still working on it, as I said in my cover email. Already I've already made a change or two, but
Me too.
let's see what you do.
Okay.
And maybe we'll respond to that rather than sending you another draft.
Okay. Mr. Harvey.
Thank you, Judge. At the conclusion of Mr. Gardner's testimony, after cross-examination, I presented Mr. Samuel and Mr. McIver just their physical appearance before the jury. I didn't say anything, so there's nothing showing what happened on the record.
This is true.
Right, and I have a photograph of what happened at that particular time that I've shown the prosecution, and I'd like to mark as Defendant's Exhibit 32, so that the record will show what it was that occurred. So I'll tender that for the record.
Okay.
Court reporter asked me not to because it's very smirking expression.
We can always redact the photo if we need to.
All right, I'm going to leave 32 here. I assume there's no objection. I've shown it to Mr. Rucker.
Well, we'll start with that. Mr. Rucker, good morning.
Good morning.
Any objection to the admission of States 32? No. Okay. I'm sorry, defendants. It's got the blue sticker. I wrote down Defendants 32, and I'm writing it on their sheet, Defendants 32. I suspect there's already a States 32 in. But Defendants 32 is admitted. Mr. Rucker, on behalf of the state, has no objection. All right. Let's turn to the state then. Someone from the state side needs to talk a little bit about Mr. Grover, respond to the concerns about Mr. Driscoll, and we've addressed Defense 32 and anything else that the state has. So let's start with whichever witness you all will be calling first, as between Grover and Driscoll.
Good morning, Judge.
Good morning.
We could just take them in the order in which they were brought up.
Okay. Mr. Grover.
Yeah, so Mr. Grover. He has been sitting in for a lot of the trial. I don't have a specific number of days or anything, and I know he's viewed the testimony of several witnesses, I believe to include Ms. Annie Anderson. And so when the defense called Ms. Anderson, I really didn't have an expectation that she would deny wearing the boots and that she would say that she left, she believed she may have left the ranch the weekend after the homicide on Sunday. And so Mr. Grover has two very, very limited purposes should the state call him as a rebuttal witness. it would be to address those two very narrow issues very, very specifically. And I intend to kind of get there pretty quickly with him. And I don't believe that anything that he would testify to would have been tainted by his viewing of the testimony of Ms. Anderson.
On the boots front, I'm assuming you think that Mr. Grover would repeat what he already told the jury, which is, I saw Ms. Anderson wearing the boots that I, Mr. Grover, bought for Ms. McIver. When I saw him, I thought of her right away, got him a special gift from me. Lo and behold, there was Ms. Anderson wearing them. He's already told the jury that.
Correct. So this weekend, I asked him to go a step further to see whether or not he could obtain a photograph or something that would help us understand the very distinct differences in the boots. And so Ms. Anderson has described a pair of light-colored boots with what I would characterize as kind of leopard print patterns on them. And what Mr. Grover has been able to show me this morning on his phone is a pair of boots that is currently sold, I believe, by Cracker Barrel, that are not the exact boots, but he will say they are very, very close. And the distinction is so very great because these boots are totally black and they've got colored swirls in them, and he'll be able to describe them and kind of distinguish them from what Ms. Anderson has testified to.
And then as to when Ms. Anderson and Mr. McIver may have left the ranch, how does Mr. Grover, I know he was up there at some point during the weekend, how would he know if this dinner, it seems like it has to have been Sunday night, because Saturday night we've got Ms. Schwal there, and it wasn't Friday night, so that doesn't leave any other nights.
Correct.
Where does he fit in?
Also, too, before I move on with the boots, I got one more thing on the boots front.
Okay.
He will also say that his recollection is that he inquired and obtained the shoe size of Diane McIver, and he understood it to be an 8.5 or a 9. And the boots that he attempted, the boots he did buy from Cracker Barrel did not come in half sizes. And so he would have purchased a 9 or a 10. He believes possibly a 10, more likely, so that she could wear heavy socks with them while she's walking through the ranch.
Okay.
Transitioning to the time in which Miss Annie Anderson would have left the ranch, Mr. Grover has a very specific recollection because he traveled to the ranch with another person. It was a co-worker from Corey, who was a notary. They had to get Mr. McIver to sign some papers, and that occurred on Monday.
Okay.
I believe that's October the 3rd, and he has a very distinct recollection about that. And he says that while there is when he saw Miss Anderson in the boots, and he says that he had a conversation with the defendant in which the defendant said to him, you know, I had dinner at Howard Seals, and he said to me, Howard Seals, that it doesn't look right that you have Miss Anderson up here so soon after Diane McIver's death. This young, pretty girl. And he has some other descriptive words. And that he said to the defendant, that being Mr. Grover, well, you know, this is a small town, and it probably doesn't look real good. And that the defendant's response was, yeah, I think I'm going to send her home, or she's going home tonight. And he says, well, okay, that's probably a good idea. They talked about business, and then Mr. Grover left. That's on Monday. Mr. Grover then saw the defendant on Tuesday, and the defendant came to Mr. Grover's home in the morning without Miss Anderson, but with Javier Hernandez. And Javier was driving the white pickup truck that is connected to the ranch. And so the conclusion logically that can be made is that Miss Anderson drove Diane McIver's Jaguar back home on Monday. So now I understand about the hearsay. I don't intend to elicit the hearsay.
The hearsay meaning Mr. Grover saying Mr. McIver says Sills said.
Correct.
Okay. So what Sills said is not coming in unless you're calling Sills. And
I'm trying to streamline because I'm really trying to rest before lunch.
Okay.
That's the intent. Well, I'm thinking about that too.
What did he say?
don't call him.
Oh,
Yeah.
okay.
And so that would be my response on Mr. Grover.
Okay. This photo of the not quite the same boots that's on the phone, how much would one of the defense attorneys have already seen that photo?
I just thought about right before you came out on the bench.
Okay. All right. So my initial thoughts are that you can call Mr. Grover to talk a little bit more about the boots. I don't think you should use a photo that is something the defense hasn't seen yet, and he's not going to say those are definitely the boots. You do have a photo that the jurors have seen a whole lot of all the boots on the wall. You can certainly talk about that and compare and contrast from that photo. But unless you've got a picture of these are the boots, we're starting to get into, well, what's the, I get it that the boots on his phone that no one else has seen look different, I guess, from what Ms. Anderson was describing.
Right.
But they also apparently are different from the boots he purchased.
Okay.
And so then we would get to you could pick any number of photos that would be different from the boots on the wall, also different from what he got Mr. Grover purchased for Ms. McIver. In terms of talking about the size of the shoe, he can talk about what he recalls in terms of the size he purchased. I don't know how you would get in his knowledge of what the size was, unless that's what Ms. McIver told him. Of course, if Mr. McIver told him, you might get that in, but if it's what Ms. McIver told him, then that would likely elicit a hearsay objection, and I don't want to run the risk of you ask it quickly and he answers while there is an objection, because unless you've got a basis for it in advance, since we're talking now, I don't think it would be appropriate to explore how did you know the size. But if he bought size 9 or 10, and that's his recollection, and certainly his recollection, you can work from that. Does that make sense?
It does. As prosecutors, you have to learn how to dance sometimes, and so, I would expect to elicit from him, he didn't know what size she wore. He did call someone to try to obtain that information. After speaking with the person, he went to the selection at Cracker Barrel, and he picked out this size, and those are the ones that he gave her.
Okay. And both sides have often tried to use the, well, it's not really hearsay, it's just explaining the conduct and everything. Who's the someone?
Phyllis Gable, the housekeeper, who actually went into the closet and looked at Ms. McIver's shoes and then said to him on the phone, this is her size.
Okay. I'm going to ask the defense a question about that to give you greater guidance on that front. And I don't have an issue with Mr. Grover talking about his recollection of what day he went to the ranch to get the signature, who he saw, and all that kind of stuff, as well as then that Tuesday morning. I understand what that's rebutting. What about Mr. Driscoll?
Yes.
And the slides.
I can represent to the court that we won't call Mr. Driscoll first. He is here. The slides deal strictly with the testimony we heard from Mr. Stan Smith and Ms. Mary Margaret Oliver with respect to the amounts of money that was under the control of the defendant as executor, and the amounts of money within a prescribed period of time. Mr. Driscoll, we only asked him to look at the time in which the defendant was executor to determine how much money was actually spent out of the estate. And I expect him to say that number is upwards of $425,000.
He is doing, it sounds like you expect him to do some of what I think Mr. Abate was trying to do with the witnesses, but neither Mr. Smith nor Ms. Oliver necessarily wanted to play in the calculator. I respect that.
Right.
But we were hearing some numbers and how to tabulate them, and
right.
He is your tabulator.
That's correct. And that's all he is.
Okay.
We asked him to do some breakouts. Like, for instance, there was so much testimony about the attorney's fees. So I asked him just to calculate all the attorneys who got paid. He has a number for that. I think it's $186,000. I asked him to look at, there was testimony from Ms. Mary Margaret Oliver about some of Mr. McIver's family members. I asked him just to tabulate those figures, and he did. I also asked him to look at the overall expenses that came out of the estate for estate related like items like inventory or supplies or whatever that number is.
Sure.
But that's about as far as I'm going to go. I won't ask him, oh, so, you know, he was doing this illegally or that's not the purpose of it. I've got some other arguments I can make about that at another time. But that is why I believe it's in rebuttal, and I believe it's relevant. And I think we can cure the lateness because it is only a series of slides, and the majority of them is he just lists out the check registry, and that just takes up several pages. But the conclusion part of it, of the demonstrative, is 3 or 4.
Anything more than addition? I don't mean to
Yeah, it's just addition.
Be dismissive. It's important work for both sides, but
Right.
he wasn't doing any. Was he doing any type of qualitative work? Well, I'm going to exercise judgment and not include these numbers, but I will include those, or was he simply adding up effectively what you asked him to add up?
That's correct.
Total up everything from date X to date Y, and then you may put it in some categories. If it is a check to Mr. Smith, I guess there wouldn't have been many to Ms. Oliver because once she was involved, Mr. McIver was not the executive.
Right.
I guess Mr. Watkins might have gotten some checks.
Right.
Okay.
That's right.
All right. Let me close the loop on the defense concerns, and then I'll see if there's anything you all need to talk about before we get started.
Okay. Before we do that, let me just say, Judge, in connection to the submitted charge by Mr. Samuel, Ms. Rudder was here.
She was here, she's upstairs.
Yes, and she is going to have, she would like to respond to the court or give some input with respect to that particular charge.
When you say that particular charge, Mr. Samuel said something this weekend that was actually a bunch of charges in an effort to do what we all agreed needed to happen, which was break accident apart, pull out criminal negligence, don't have the voluntary manslaughter, lesser included language, although it doesn't seem to have disappeared all that much after all. But either way.
Right. Either way, she would like to be heard on that and give some input.
Okay.
I want to flag for the court. I have spoken to Mr. Harvey this morning about the jury view and the vehicle itself.
We'll get to that.
Okay.
I want to close the loop on Grover and Driscoll, and then we'll turn to that. You started, Clark Palmer, so you're welcome to pass the baton. I don't remember who handled Mr. Grover before. Great, then it's perfect. Tell me what the objection would be, because maybe we'll work through it now, if I allowed Mr. Rucker, or whoever's going to question Mr. Grover, to allow Mr. Rucker to have Mr. Grover recount to the jury his recollection of, I saw some boots at Cracker Barrel. I knew they were perfect for Ms. McIver. Didn't know what size. I get Phyllis Gable on the phone, and asked her to go into Ms. McIver's closet and look around. And that's the extent of the research, if you will. Okay, did you end up buying the boots? I did. And what size did you get? I can't remember for sure, but it was either a 9 or a 10.
Okay. So when Mr. Grover was on the stand for direct, I went back and watched his testimony this morning to remember, well, did he describe the boots? Did he say what size he purchased? He only described them as being rain boots with a western flare. He didn't describe what size he bought. He didn't give, I was going back to look to see, did he say a color or a pattern? He did say something about a pattern, but not specific. So now that he has sat in and listened to Ms. Anderson testify, and I don't know when he started talking to the prosecution about the boots. I mean, I understand he showed this picture this morning, but was there some conversation with the prosecution before that? I think he passed them a note during Ms. Anderson's testimony. So now we've heard from Mr. Grover you know, oh, I can't remember, but it could be a 9, or maybe I went up a size so she could wear thick socks, and now magically he has purchased the same size that Ms. Anderson says that she wears. And he's going to get up and say, effectively give a description that is different from what Ms. Anderson gave on the stand.
Well, I mean, arguably, the description he gave was different. I'm not, because he says Western style, and Ms. Anderson is saying, you know, it's these repeating color patterns, and then she references some boots in the picture. You know, I can't tell you which specifically is the pair I wore, but it's one of these 2 or 3. So I'm less concerned about the, hey, Mr. Grover would come in and describe a motif that's different from what Ms. Anderson described. I think that's already happened. But I'm sensitive to your concern that if, I did not go back and watch the testimony.
Yes.
I didn't go back to watch anything at all. But I have no reason to doubt you that that's how that played out. So would you want to have Mr. Grover come in here so we could ask him, you could ask him some questions outside the jury? Why, it sounds like that's what we need to do, to work through a note, or what did you and the state talk about, et cetera. Because then we'll have more than your understandable concern / speculation. We'll have a record of, well, actually, here's how it played out. And I'll be in a better position to say that that introduces some complications we don't need to introduce. And you can talk about the time at which you visited the ranch, but we're not talking about the boots. Or we can't talk about any of it, or you can talk about more.
Well, I would just say with regard to the boots, I mean, this to me seems like exactly why we have the rule about sequestration. To not introduce into this trial this kind of factor that somebody may have been sitting here and have their testimony affected by what they have heard on the stand. And if the prosecution, and I agree that, you know, what's in the record already is that he has described something that's different from what Ms. Anderson said, so then they're free to argue that. We don't need to bring him back in their rebuttal case. I have less concern about him kind of establishing the timeline of when Ms. Anderson was there, because, I mean, I think it's already been established on direct, but it is consistent with what he already said, which is he gave this recall of the timeline, and it is different from what Ms. Anderson said. So I have, that we've already heard, and I have less concerns that that may have been influenced by something he has listened to.
Sure. I understand your concern, and I can't know how much of the way Mr. Grover's initial testimony played out because the state either didn't realize there was going to be a disagreement, or at that time it wasn't particularly salient, or why would Ms. Anderson say, recall that she left on Sunday when every other witness they had talked, I mean, maybe Javier Hernandez, who didn't get called for, I'm sure, lots of good reasons, also said, sure, Ms. Anderson was here through Monday when she drove away alone in the Jaguar. So not pressing Mr. Grover on that
Right.
4 weeks ago,
Right.
I get it. The boots is different, and I think we'll get Mr. Grover on the stand in a moment to work through that. Anything more on Driscoll?
Oh, the only thing I would add on Driscoll is, so, you know, a couple of the slides I'm less concerned about because I just know looking at them that the numbers are correct. I agree he summarizes the amount of money paid to the lawyers. That's consistent with what we've already heard. I mean, there's one firm in here we haven't heard about, but they only got $600. So I'm less concerned about that. It's the other stuff, the payments. He has another, let me break it down this way. He's got one slide that says opening balance of the estate account, the total number for the deposits, and then the total payments out of the estate. I have no idea if that number's right. I'm not saying I have any reason to think it sounds wrong, but I just haven't done the math to check. But then he has 1, 2, 3, 4, 5, 6 slides that look like they just repeat what is in the bank records already. They seem to be kind of selected excerpts from the bank records. Again, I have no reason to think they're wrong, but I have not had any chance to go through the records and verify those. So I have concerns about those. He has one slide about payments to Mr. McIver's will, Ms. McIver's will and testament beneficiaries, where he shows James Hugh got $10,000, Phyllis Gable got $13,000. Again, I don't know if those numbers are right, but I have less concern about that dollar amount. I'm not concerned about the payments to attorneys. But then he has payments to individuals / others, where he summarizes payments to Tammy Johnson, inventory expenses, and he lists what he thinks inventory expenses are, payments to the defendant's family members, Dickerson Communications, and then the villa at Buckhead Heights HOA. I'm concerned about those numbers because I haven't had the chance to go and just look and see, well, is there anything else that ought to be included as inventory? Are there some of these things that he's called inventory that aren't inventory?
Okay.
So that's kind of how I break that down. And I have, depending on who we call this morning, I have Jay Grover, the sleep expert, and Dean Driscoll. So
you also have two amazing, capable legal partners next to you and an investigator. And in the same way that I have watched the state fan out work because there might be things piling up on one attorney, I would hope that your team would support you because it sounds like Mr. Driscoll won't be the first witness called. To look at the priority areas, you said you're less concerned about the tabulation of the amounts paid to the attorneys. You're a little more, and concerned may be the wrong word, just less familiar with it, so you'd want to check the numbers as well. What's been given to some of the beneficiaries, Mr. Hugh or et cetera. And you've got some folks who might be able to assist with that in the way you've prioritized it as well. So it's suboptimal that the slides came when they came, but given the nature of the work that the state asked Mr. Driscoll to do, it doesn't strike me that it would be a little tricky to check some of it. Maybe in my mind the exception would be, what do you call inventory expenses? Because the others seem to be, either Mr. Hugh got a check or he didn't. And we're talking about just a few months of the estate account, and I didn't get the impression that there were thousands of checks.
well, I'm just asking the court for some time.
Okay.
I mean, even if they do the work, I still need some time to sit down and get prepared for his examination.
Well, it sounds like there's some other things we can work through, so I'll make sure Mr. Driscoll doesn't get called in the next 5 minutes. So we'll need to get Mr. Grover in here in a minute. State, you had wanted to talk about the jury review. Anything else?
Your Honor, this weekend, I know we did send the court a request for the court at its discretion to grant some additional time for closing arguments for both sides, actually. And just wanted to see if the court had given that some consideration. And if so, if the court can agree on the amount suggested by the state, that perhaps some amount as a compromise perhaps could be reached, in as much as we've had so many weeks of testimony and so many witnesses and so many exhibits. The burden is on the state, and we did take a week off in between, and so there's just a lot to recount. And having worked on it this weekend, I don't need the amount that I asked for, but I asked for it out of an abundance of caution, understanding I will come in under that by a great bit. But the statutory prescribed time, though, would be difficult for me to accomplish all that I would like to.
Okay. What about the jury review?
Jury review, I spoke to Mr. Harvey over the weekend. I didn't speak to him, we exchanged text messages. And what I did was yesterday I had crime scene technician Trobit, who was the individual who processed the vehicle initially, come out to where the vehicle was stored. He reinserted the dowel or the rod through the seat. And I believe he's here this morning And I expected he would be able to say under oath that he was able to restore the vehicle based on his report, the photographs, back to or very close to the position that the vehicle was in when he first saw it, meaning that the seats had been adjusted back to their original positions, and that the dial has been reinserted, but it's reinserted in a way that you can get in and out of the back seat. He will say that the cut that's in the front of the seat was not there when, of course, he processed the vehicle.
Where is the cut in relation to the bullet defect in the front of the front seat? Is it below it or above it, or the side?
It's above it and off to the side.
Okay.
Along the seam at the top of the seat. Not the top, but the middle of the seat. He'll say that it wasn't there, but it does not impede the trajectory in any way, and it didn't prevent him from reinserting the rod. They are probably about, my best guess, maybe 5-6 inches away from each other.
Okay.
And
Mr. Hardy, I'm sorry to interrupt, but just so I can close the loop in my mind on this cut. Did Mr. Gardner testify that when he examined the vehicle, the cut postdates Mr. Gardner's exam?
I don't know. I don't think he covered that. I don't recall that he mentioned anything about the cut.
Do you know if the cut was already there when he checked out the car?
I don't know because I wasn't there. Mr. Samuel was there.
Okay.
Regardless of what he will testify to, I talked with Mr. Rucker, and prior to the time we go down there, I want an opportunity to go down there. Neither Mr. Gardner nor Chris Robertson was available this weekend or today to go with me, but I'd like to go down, I'd like to measure, and I think that's just reasonable before we take everybody.
100%, and if you want Travis to be down there to narrate for you what he did, let's get him down there as well.
I do.
And I was going to get to that in a minute. I wanted to make sure you were as comfortable as you could be and figure out what you had done or what we needed to make sure you could do. I just want to make sure this cut isn't going to, I'm going to say to the jury, unless you guys say, don't, there is this cut. It has nothing to do with the testimony you heard about. It was not there before. It was part of the way one of the experts, or one of the witnesses who was processing dealt with it. I just couldn't remember if Mr. Gardner had shared the conclusion that the cut doesn't affect anything. But I'm not going to put any words in his mouth. If he had said that as well, I would worry less if Mr. Harvey was saying, oh, this cut changes everything. As only it does.
And so Mr. Harvey just asked this morning if he'd be given the opportunity to do that. I have checked, and so as I understand it, the vehicle is on its way here, and so, you know, it's at the court's pleasure whenever.
So, job one, once it gets here, would be to get Mr. Harvey down there with Traugott and someone from the state.
Yeah.
So that Mr. Harvey can see it and ask Traugott anything he wants about, well, how'd you do this? And if there is a discussion about how far the dowel should, the only variable it seems like you guys might disagree on is how far back towards the rear passenger should the dowel be projecting. Right. Sure seems like it ought not to project so much that you can't get in, because we saw Mr. Samuel sitting in there and he was able to hold his red gun, and then your expert was there with his thumb gun, finger gun. So hopefully the jurors would do the same, so you guys will need to agree on that. Short of that, it seems like we're good to go, and the timing really ought to be, and one way to give Ms. Clark Palmer just oodles of time would be to, before Driscoll testifies, we go do the jury review. But I'm not dictating schedule, but that'll buy lots of time. So, were there any other mechanics or logistics of the jury review? No. Okay. Mr. Samuel or Mr. Harvey, as I understand it, I should ask one of you two, your thoughts on length of time for closing?
2 hours of time.
Okay. All right.
Unless we need more.
You don't?
Which we don't.
You don't?
We do not.
Okay. Mr. Harvey, your concern or request vis-a-vis the jury review was what you just got on the record. You would like a chance, very understandably, to see what it looks like right now, talk to Traugott, have him show you what it was he did, and then you can let me know after that if permission to have the jury look at it?
Yes.
Okay. Chief Wacocha, when you learned that the vehicle was downstairs, if you could let the prosecution know so they could then get word to Mr. Harvey, if we're in the middle of a witness that he's not necessarily having to plug into, it'd be great if you guys went on down there to look at it, because obviously you can't send a jury down there until everyone gives the okay. All right, why don't we get Mr. Grover in here, please? And David Kane, can you let the jury know we haven't forgot about them, we're just working through things. We appreciate they were here on time, we just need a little more of their time. Thanks.
Raise your right hand for me. Do you swear or affirm that the testimony that you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may have a seat. Please state and spell your name for the court.
J. Grover, Jaygrover.
Mr. Grover, we've got you in here without the jury just to talk a little bit about what's been going on since you last testified. I'm going to let the two sides ask you questions. I just wanted you to know why there's no jury in here.
Yes, sir.
Ms. Clark-Palmer, do you want to start, or do you want to have the state, both of you can talk with Mr. Grover about this? Okay.
Mr. Grover, I understand that you showed Mr. Rucker a picture of some boots this morning.
I did,
Can you
of
pull-
a boot.
Can you pull that back up so I
Sure.
can look at it? Do you mind if I go take a picture of your
No,
phone?
or you can, either way.
I'll bring it back. Were you present in the courtroom when Annie Anderson testified
Yes, ma'am.
for her entire testimony?
Yes, ma'am.
Can you tell me how the boots in this picture here, how are they different from the ones you purchased for Diane?
How are they different? They're similar. It was a little bit different. The actual shape of the boot and the pattern's not what I recall. That it's exactly the same. Without as many colors on it.
How would you describe the pattern that was on the boots you bought for Miss McIver?
I recall it having more of a fleur-de-lis kind of pattern. Something it struck me as a little bit more of a Western style than this one. That's just basically flowers.
Okay. But you heard Miss Anderson describe the boots that she was wearing the weekend after Miss McIver died, right?
Yes.
Okay. And your recollection is that her description is different from the ones you remember seeing her wear?
Yes. The only thing I really recall about hers, I think she said they were white or cream colored, and she talked about the size, but I don't recall anything else specific about what she said.
When did you tell Mr. Rucker during Miss Anderson's testimony that the size Miss Anderson gave for Diane McIver was different than what you recall Miss McIver, her shoe size being?
During the testimony, I don't recall, because I don't recall during her testimony saying something. I may have, but I don't recall that.
When did you tell Mr. Rucker that your recollection about the boots was different from what Miss Anderson testified to?
About the size or the style and all?
Either.
I may have said something about it then, but I specifically said something about it on Saturday of this week.
What happened on Saturday?
The district attorney's office called me and we discussed the boots themselves.
Just a phone call or a meeting?
Just a phone call.
All right, who was on the phone?
Initially, I believe it was Chief Okocha initially, and then Mr. Rucker, and there were possibly others in the room with them. I think at one point Ms. Convery and I either text or talked, but I did not meet with them.
What was the text with Ms. Convery about?
I think that she also sent me a boot style.
A what?
A boot style.
Meaning a picture, or she texted you words
Right.
describing?
A picture, Your Honor.
Okay.
And what did you say about the picture?
I think I can refer and tell you exactly what I said.
Go ahead.
I said similar, but I recall more Florida lay pattern.
Can I see the picture she sent you? Okay. Did you see the picture, it's a defense exhibit of the boots at the ranch?
I did.
Okay, when did you see that the first time?
I believe in the courtroom that day.
Okay. When somebody was testifying?
Yes.
All right. And did the state ask you about that exhibit?
Did they ask me about it when?
Well, when was the first time they asked you about that exhibit?
The first time that I specifically recall would have been over the weekend, but they quite possibly may have asked me sometime prior to that
Okay.
if I recognized any of the boots.
And do you recognize any of the boots in that picture?
No.
Okay. And when is the first time you told the state what size you remember purchasing for Diane McIver? Was it before or after Annie Anderson testified?
I don't recall. I don't recall if it was before or after when we talked about that.
When is the first time you recall describing for them what the boots looked like?
Other than rain boots with a Western style, probably didn't get into any more specifics until recently.
When did the state tell you they were going to call you to testify today?
In a text on Friday afternoon, Friday early evening, afternoon or evening, then I believe Investigator Griffin, and again I can refer and tell you exactly what it said and what time, but that there was a possibility that they may call me and that Mr. Rucker would contact me over the weekend.
To call you to testify about the boots and maybe some other things?
I don't think that it says anything about the boots. Again, I can refer to and tell you exactly what the text says.
Okay. After you heard Annie Anderson testify, at any point did you say to anybody at the DA's office, that's not my memory, or what she said is not different than what I remember, or something like that?
And again, I don't have any specific recollection of that, but I very well may have, but I don't have any specific recollection at that time.
Well, what do you remember saying to them after Annie Anderson testified?
Well, again, I don't have any specific recollection if I said something to them then, or maybe to someone else, someone else in the gallery, or I don't recall specifically talking to any of them about it then.
Well, okay, so let me maybe ask a more broad question. Before Saturday, did you have any conversations with anybody from the DA's office? Between the time Annie Anderson testified and Saturday?
About anything?
Anything?
Yes.
Okay, what conversations did you have?
I I can't recall every conversation that I've had with someone from their office. I speak to them on a daily basis.
About what?
The trial or you know.
About the testimony being given at trial?
Not necessarily about the testimony, but just something in general. There's been a few things that I've pointed out, or things that I have realized are different than, not necessarily about what I've testified to, but possibly what others have said, or something that I know or believe that I know to be different than what's been said.
You mean, for example?
I'm going to have to think about that.
What about text messages? You told us about the text exchange with Ms. Conver. Do you have any text messages with anybody else from the DA's office?
Possibly.
Okay. Can you look back and see if you have any text messages between when Annie Anderson testified?
When did she testify?
I think Thursday, last Thursday, the 12th. Do you have any text messages between the 12th and the 14th?
I don't see any with anyone else from the DA's office. The only one, let me make sure. I had the one on Friday at 5:32 p.m. from Investigator Griffin.
What's that one say?
This is Friday at 5:32 p.m. Hi Jay, Clint wants to put you up for a moment on Monday morning 9 a.m. He will call you. Thanks. And I just responded 10-4.
Okay. When you got that text, did you know why you were being called to testify?
No ma'am.
And had you told anybody from the DA's office before that your memory is different from what Andy Anderson testified to?
Well, again, I think I said that. I'm not sure. I may have, but I cannot specifically recall that I have. But I may have.
I have a question, Mr. Grover.
Yes.
You testified just now that pretty much on a daily basis you've chatted with folks from the DA's team. I'm just trying to put that in context. Are you referring to a scenario whereby you might say, good morning guys, what are we looking at today? Like, were you planning on calling? Or is it more of a skull session where you're sitting down and saying, hey, if you're going to call so-and-so, you need to ask this, or I'm concerned, I remember something different about this. Can you get it on that spectrum where you're a participant in what they're thinking and doing versus, hey, I'm an interested observer and I'm just curious, tell me what the plan is for today?
Yes, sir. I'd say it's a combination of both, Your Honor. I cannot specifically recall anything in particular. I may think about it, 5 minutes from now. But yes, there have been specific things that I've pointed out. I think I may have even passed them a note or two with something that I recall that's different or something relative to the trial.
Okay.
You do think you passed them a note or two?
Yes, ma'am.
Okay. About testimony that's been given in court?
When you
I mean, what else would the note be about?
Right. It wasn't like you want to have lunch. But yes, it was something about what was going on.
Because you tell them there have been times when you've said to them, hey, that's not right. My memory is different. I heard something else.
That's correct.
Okay. All right, let me show you this picture, which I showed to the state. If any of these boots either look like the ones you bought Diane or look closer to the ones that you bought Diane.
Look like or look closer?
You tell me.
Yes, that look closer.
Okay. Which ones are you thinking look closer?
Well, I've got a thought that it's more like these here.
Okay.
But closer, but you're saying those still aren't boots I bought Diane.
Those don't appear to be, as I recall, but the ones that I said more like a Florida Lane pattern. But that one there would be the ones that I would say are closer.
Closer, okay. Okay. Do you remember how much you paid for it?
It's been, what, 2015? Not a lot. I would think $40, $50, something like that.
And do you remember what brand they were?
I'm in the preface.
Okay. We just like to print that picture so you can. Do you have any notes that you've made that are in your possession about anything that's happened at trial?
I don't believe so.
Okay. And I know you said you may have passed a note or two up to the DA, setting those aside. Have you ever written anything out or sent them an email or a text message about, the testimony at trial?
The testimony since the trial has started?
Yes.
Don't believe so.
Possible?
I don't recall any.
Okay. All right, I don't have any other questions. I just will get a copy of this picture.
Sure.
Momentarily.
Mr. Rucker, do you have any questions for Mr. Grover?
Just a few. Do you remember what time did we speak on Saturday?
It was in the afternoon. It was sometime in the afternoon, 2, 3, 4 o'clock, something like that, I believe.
Okay. And about how long was our conversation on the phone?
It was short, just a few minutes. I'd say 5 minutes or less.
Okay. And during the conversation, can you tell the judge, what did we talk about?
That you may possibly call me as a witness, and specifically about, or I think I asked, and it was about the boots and my visit to the ranch on the Monday following Diane's death.
Okay. And when we were talking about the boots themselves, did I ask you to do something?
You did. You asked me to look online and see if I could find something that closely that matched or was somewhat similar to what I recall. And you also asked me to check bank statements to see if I could find either a credit card or a debit card statement, either online or as a hard copy. And I don't recall whether you asked me to or whether I did it on my own, but I actually went to the Cracker Barrel myself to see if I could find something similar.
Right. And then can you tell the judge, is this morning the first time I had an opportunity to speak with you since the Saturday phone call?
Yes.
Okay. And when I saw you this morning, is that when you showed me a photograph on your phone?
It was just a few minutes ago.
Okay. And I asked you about the results of your online search for any of your debit card bills or credit card bills.
Yes, sir, you
And
did.
can you tell the judge what you told me?
That I did search online, and that I can only go back as far as October of 2016 was as far back as it would allow me to look online.
And this morning when I spoke to you, can you tell the judge, did I ask you if you had any specific recollections about what size boots you would have bought?
Yeah, you did ask me that, and I answered
And tell the judge what you told me this morning.
that everything about the size, that what I recall is that I had called the housekeeper, Phyllis Gable, to see what size, if Diane had any boots in there in her closet at Kingsborough, and if she would look. And she looked, and she said there were no boots. My recollection was that she said there were some shoes in there, and they were an 8.5. And I told her thank you while I was there to purchase the boots. Again, this is based on my recollection that the salesperson there said they did not come in half sizes, and that I bought either a 9 or a 10 because they only had the certain size, and it was larger, and I figured you could wear socks with them because they were rain boots, or not like, cowboy boots that you'd wear. And I bought one of the sizes. What size it was specifically, I do not know.
Okay. And Judge, I don't know if I need to ask any questions about the conversation with the defendant on Monday. Okay. Okay. All right, I think that's all my questions.
I marked this as defendant's 33. That's what we're to.
And this is a picture of boots from the auction?
Nope, picture of boots, just a picture of boots that I showed to Mr. Grover and asked if he could identify any of these as being closer to the ones that he bought from Ms. McIver.
This is different from the wall of boots at the range.
Yes, it's a different picture.
Okay.
Can you just write your name and draw an arrow to
Sure.
the ones you said were closer?
Sure.
And I'm just tendering it for the record at this moment.
Sure.
Okay. And I don't have any other questions.
Okay, Mr. Grover, if you would step outside, and we'll get you back in here shortly. Thank you. Okay, Ms. Palmer, anything you want to add to your argument? You've, I think, made real clear what your concerns are in terms of Mr. Grover having been in court for Ms. Anderson's testimony. We've been able to ask Mr. Grover about that. Anything you want to add?
Your Honor, just, the court heard what Mr. Grover said, which is that he has been here listening to testimony, providing his thoughts and commentary and input to the state. He went and did some investigatory work on his own on behalf of the state this weekend to try and find these boots so he could come in and contradict what Ms. Anderson said. And I think this is a classic situation and a reason why we have the rule of sequestration to avoid this type of witnesses come in and not directly, but through inference, commenting on another witnesses.
Okay. Mr. Rucker, anything you want to add?
No, sir.
So I very much appreciate the concerns that Ms. Clark-Palmer has flagged. It's a complicated situation because, as we've now heard from a number of witnesses who've frankly gotten very understandably emotional about it, Mr. Corey, Mr. Grover, Mr. Rickard, this is Ms. McIver's family. And of course they want to be in court during the course of these proceedings. And so I don't think it was an error in judgment on the state's part to say, Mr. Grover, you testified, now you can be in court. Mr. Grover has been here, if not every day, most day, along with other colleagues from Corey Enterprises, as they should be, given the nature of the relationship that they enjoy with Ms. McIver. And so it's sort of it is a dilemma that these witnesses find themselves in. They want to be here, in many respects they ought to be here, and yet the way the trial played out, there's at least one witness who has some additional information that could be shared that is arguably relevant and rebuts a little bit of the defense case. So I think that Ms. Clark-Palmer has made a thorough record of some of the countervailing factors that would suggest, gosh, all other things being equal, Mr. Grover had a chance to testify and the state shouldn't be allowed to call him again. I think the state would have been doing Mr. Grover a disservice to say, I don't have a perfect crystal ball, but it's conceivable that you might need to testify in our rebuttal case 4 weeks from the date you testified, so you have to stay out of court. That isn't what the state did, and I'm not faulting them for that. I think that the defense, through cross-examination, can explore with Mr. Grover much of what it explored just now, maybe minus some of the hearsay, to give the jury a flavor of the defense's concern. I am going to allow the state to recall Mr. Grover to talk about the boots, but in a more limited fashion than the state was seeking to. Mr. Rucker, you're not going to be able to share the photo from the phone with him that he found or someone found. In fact, unless the defense opens the door and they choose to do that, I'm not going to allow you to have Mr. Grover talk about stylistic differences. You can talk to him about the size. So this whole process of, I see the boots, this is, I know I want to get this, I reach out to Ms. Gable, ask her to check, then I go to the store, and of course you can't say what the clerk said, you just say they were only available in whole sizes, and my recollection is it was this or this. It's a tentative recollection, and the defense can hammer away at that if it wants, but I find that that's relevant, it rebuts, and it's appropriate to allow Mr. Grover to talk about that. And as for Mr. Grover's recollection about the Monday encounter with the defendant, the Tuesday morning encounter, fine, as long as you do what you said you were going to do, which is stay away from what would be hearsay as to Mr. McIver saying, Sills told me X. So the defense has preserved its concerns about that, but Mr. Grover may testify with those constraints. If the defense ends up showing pictures to Mr. Grover about, does it look like this or look like that, and you think it's opened the door enough, let's have a sidebar about whether you can use the photo from the phone, but don't go there unless we've had that conversation and I've said it's okay. Is the vehicle here? You don't know? Okay.
just one more thing on Mr. Grover. We'll submit a instruction for the jury to be included that they can consider, what now? We'll do, yeah.
You should give a limiting instruction.
Yeah. Okay.
Not limiting, but a cautionary instruction that he violated the rule of sequestration. That's a little stronger language.
Right, that's not at all what I'm going to say, because I don't know that he did, but events, I will bring to the jury's attention that Mr. Grover was here and has heard some of the testimony, and he's not an expert witness, and so that may be something they want to factor in. But I don't find that he violated the rule.
That's the way we're talking.
Okay.
But there is, I mean, Rule 615 specifically says that's one of the remedies. I mean, one remedy is you exclude the testimony. Another one is you tell the jury there's a reason we have a rule of sequestration. He was in the court, and you may consider that in evaluating the credibility of what he's saying. And that's what the whole remedy is, that you're supposed to advise the jury. The purpose of the rule of sequestration is, well, we have everybody just sitting here all the time, and why ever follow a rule of sequestration if the only remedy is, we'll let the jury know he was sitting in the courtroom? Well, they can see that.
Well, I've already made a record of one reason why this doesn't strike me as a classic case of violation where a plainly adverse witness, maybe at the state's instruction, is hiding back there, and you're doing your job, which is focusing in this direction. I think appropriately analogize Mr. Grover being in here, his family being in here, and certainly the state needs to make that judgment call. It may be that you keep the mother of the victim out of the court because you know she's going to be testifying in rebuttal. So I'm not disagreeing with you, but again, this is why I have the rule if things like this happen. This isn't the kind of thing,
I think the reason, my response to that is, you're right, it's fine, you can have the family in court, but there's a price to pay. You're not going to be able to call the witness. I mean, it's just a balancing that the DA has to make. It's possible Billy Corey may need to be able to explain the lawsuit, right? Why is there $975,000 less than the estate than we thought there was going to be? I mean, there's all kinds of things. And you need to tell the witnesses, you're free to stay in here, but we're going to lose the opportunity to call you if we need to. And in a trial like this, it's absolutely predictable that things are going to come up. And, the same arguments, but...
No, I understand your perspective.
And here we have a witness who's, casting votes. It's not just, he's just sitting here and happens to have heard something. And he's been actively involved, passing notes, correct that. And then they find out Saturday and wait till Monday morning to tell them. We could have not actually looked for the groups. Lots of things we could have done had the DA given us more warning than at 9:20 for the first time telling us what we got the witness list since I got it at 11:50 last night.
Okay.
Well, we got the names.
Right. The two sides have made these boots a lightning rod from long, long ago. So if there was a desire to get your hands on the boots, that's something that might have been the kind of thing you want to show Annie Anderson and have her try to put the boots on, and they don't even go past her big toe. The availability of the boots on short notice is less compelling, but I hear your point, and I will say something to the jurors, short of violating the rule of sequestration, to draw to their attention the very reason why we ought to have had the conversation we did, and why Mrs. Clark Palmer appropriately brought this to my attention. What's the update on the vehicle?
It's here.
It's here. All right. And Mr. Troutgate is here? Great. So, Mr. Harvey, I don't mean to tear you away from the Grover exchange, but if you're able to go with someone from the state and Troutgate, maybe Chief Wacocha, that would be good to get your input sooner rather than later on how that vehicle is looking. Great. Anything else, Mr. Rucker, from the state? No. Okay, Ms. Clark Palmer, you got the photo and it's in at least the record, defense 33. So you're good to go?
Yes.
Okay. Then let's bring the jury in. Dave, I understand this is, they have gone to sleep. Wake them up, and when they're ready to come in, have them come in.